We recently looked at resolving conflict through negotiation, and up until this point, we've examined managing conflict situations on our own. However, on occasion, it's necessary to bring in a third party into the conflict resolution process. Sometimes parties reach an impasse and can't progress any farther without the assistance of a neutral third party. This is when it's necessary to bring in a mediator. The textbook defines dispute as a conflict that has reached a point where the parties are unable to resolve the issue by themselves due to a breakdown in communication, and normal relations are unlikely until the dispute is resolved. It's important to note that not all conflicts are alike. Consequently, not all methodologies for resolving conflicts will work in every situation. Occasionally, parties seek the help from a third party because they cannot resolve the conflict by themselves. Mediation comes in various forms. The conflict situation and the parties involved determine what form of mediation is needed. Perhaps there needs to be an informal mediator or a formal mediator. Mediation also ranges in terms of the degree of involvement of the mediator and the mediator's influence in resolving a dispute. Mediators may or may not be certified. However, mediators should be trained to act as a neutral third party in order to effectively manage and resolve conflict situations. As I mentioned earlier, the role of the mediator may be formal or informal, and there are different levels of how involved the mediator will be in the conflict resolution process. Here are some various forms of mediation that may take place in conflict situations. An example of an informal form of mediation may be when someone acts as a coach. Coaches work with individuals to enhance their ability to communicate, to express their needs, and to listen to the other party. Importantly, to foster a more productive dialogue. They may also work with individuals to develop strategies for resolving the conflict. If the situation calls for formal mediation, that's where a neutral third party facilitates the communication between the conflicting parties so that they may work out on their own a mutually acceptable agreement. Oftentimes, formal mediation is used in divorce settlements and child custody disputes. However, it is rarely used in situations such as a union labor dispute. In contrast to mediation, where the mediator serves as a neutral third party and really facilitates the discussion so that the parties may make a decision on their own, the process of arbitration is different. In arbitration, you still have a neutral third party, but this person considers both sides of the dispute and makes a decision, which is more binding than that of a judge in the legal system if both parties have agreed in advance to abide by the arbitrator's decision. Once a decision is made through arbitration, it may not be appealed or contested. Sometimes arbitration is used, for example, when there are disagreements involving union labor groups. Also, on occasion, conflicts dealing with consumers may be settled through arbitration. For example, the next time you purchase a cell phone or a cell phone plan, take a look at the volumes of information that's provided for that contract. Chances are there will be a statement in there that says you will agree to arbitration if a dispute occurs. The last form, adjudication, is probably what most of us think about when we're considering how to resolve a conflict, and this is a form that involves the legal system. Typically, this involves a judge and a jury and attorneys who prosecute or defend the parties in a case, and a decision is made. Unlike arbitration, however, decisions made through the legal system, through adjudication, may be appealed by either party or both. Conflicts dealing with criminal and civil issues oftentimes are settled through adjudication. Your textbook also lists two other forms of mediation. One is an ombudsman. This is an individual who helps cut through the bureaucracy or red tape on behalf of an individual. Oftentimes, these conflicts deal with the government or perhaps a large healthcare institution or educational system. In other words, the organization or the system is so large that a neutral third party is needed to help navigate it. The other form of mediation that your book mentions is conciliation. This is a neutral third party that travels back and forth between the conflicting parties who are unable to meet for a variety of reasons. Note that this textbook was published before virtual meetings were even a possibility. Therefore, my guess is that in today's world, there's really no need for someone to serve through conciliation. Now that we've talked about the forms of mediation, let's look at the benefits. Essentially, mediation produces better results than adjudication, and it costs less. If it's conducted well, parties are also less likely to pursue legal actions. Mediation restores communication and helps to normalize relations between the two conflicting parties. In fact, the primary role of the mediator is to facilitate communication between the two parties. Another benefit is that mediation allows for full participation by the conflicting parties. In essence, the mediator serves as the gatekeeper to ensure that communication continues to flow and that one party doesn't dominate the conversation, but rather all parties have equal time and opportunity for input. Mediation is also found to have a high success rate in terms of resolving conflicts. In fact, the textbook states that it's estimated that once parties have agreed to mediation, at least 80% of the time they are able to work out an agreement that is acceptable to both parties. Importantly, unlike attorneys who take a particular side of an issue, mediators do not take sides. They are unbiased facilitators of communication between the parties in a private setting. A mediator is the neutral third party who has no decision-making power regarding the outcome of the mediation session, or sessions in some situations. Essentially, mediators attempt to create a non-threatening and a constructive environment to encourage the disputing parties to communicate, cooperate, and work out their own mutually satisfying outcomes. As you're processing this information, think about your own experiences with conflict, and have you sought to get the help of either an informal or a formal mediator, or perhaps you've been asked to serve as a mediator. Either way, it's important to recognize what skills are required to be an effective mediator. The first skill is one that I've stated repeatedly throughout this video. Mediators are expected to be neutral, unbiased, and there is no reason for them to take one party's side against the other. Certainly, in order to be neutral, a mediator should not be related to one of the conflicting parties. Your textbook states that according to the Center for Mediation and Law at Harvard Law School, the mediator should have what's called a subjective neutrality, in which he or she honors the validity and truth of each person's story without deciding who is right or who is wrong. The second skill is that a mediator must be able to maintain confidentiality. If you have trouble keeping secrets, you should not serve in the role of a mediator. The third skill is that mediators must be competent communicators. They not only must be able to express themselves well, they must be able to do so without being biased or subjective. It is their responsibility to navigate or orchestrate the conversation, to facilitate discussion, and certainly not to monopolize it, and to make sure that all parties have equal time in the discussion. Competent communicators will use terms which are descriptive rather than judgmental. For example, it would be more effective to say, "It appears this information is affecting you," which is being descriptive, versus "It appears that this information is making you angry," whereby you are making a judgment. Competent communicators are also specific in the words they choose. They focus on behaviors that can be changed, and they give feedback, but only when it's requested. And when it is requested, the feedback should be timely. As I mentioned earlier, the fourth skill is that mediators facilitate the communication. They do this by encouraging cooperation and really discouraging competitive behaviors or language or comments made by the parties. They work to create a safe and constructive environment where there's really no room for hostility and certainly no room for threats. in situations such as that, then the mediator has to be strong enough to halt those kinds of behaviors and to redirect the conversation or the discussion into a more productive channel. Finally, mediators are open-minded. They accept and support whatever resolution the parties agree to, because the mediators have no decision-making power with respect to the outcome. They have to resist the temptation to act like a judge or act like a jury, or even say to themselves or under their breath, that was a really, really bad choice or something like that. They are the neutral, unbiased third party. The final information that the authors present in this chapter is what the mediation process looks like, step by step. The first step involved is what your authors call the intake process, and this is when either one or both of the conflicting parties decide to seek mediation, or perhaps someone has consulted a mediator and that individual has helped them to recognize that it's going to take mediation to resolve the conflict. This is a very important step because essentially the parties are recognizing they can't resolve this on their own and they need the help of a third party. The second step then is where the mediator will make an opening statement. This is where he or she will provide a list of rules or the behaviors that will govern the mediation process and also explain the mediator's role in the conflict resolution process. It's here that the mediator will really reinforce that the whole goal of this is for both parties to work out a mutual agreement between themselves. They are to work towards solving the problem, not to attack or blame one another. They're also encouraged to talk, to take turns, and interestingly, your book says that the parties should look at one another when they are going through the discussion. They should not direct their attention to the mediator, but rather speak to the conflicting party. And the parties should openly share their thoughts and feelings and focus on the future. Following the opening statement, each conflicting party has an opportunity to speak. Following the opening statement, then each party has an opportunity to state his or her position and share their feelings about the problem. It's from these opening remarks and comments made by the conflicting parties that the mediator can identify the issues that are to comprise the agenda for the mediation discussion. Through the comments that the party shares, then the next step is where the mediator finds common ground on which to build agreement. Common grounds may consist of attitudes, values, behaviors, expectations, and goals that the parties share, and this can serve as a basis for agreement. The mediator may also use fractionation, which is what we talked about in the previous chapter, which involves breaking down complex issues into smaller, more manageable pieces. By breaking down the issues into smaller components, this allows the parties really to achieve small successes until the larger issue can be resolved. The fifth step is where the parties reach final agreement. The mediator keeps track of all the areas that the parties have agreed upon as the mediation has progressed, and writes a draft of all points of consensus. In the final agreement, the mediator uses clear, specific details which spell out who, what, when, where, and how. The authors of your text state that it's helpful to think of the agreement as a list of behavioral commitments because this itemizes the specific actions that each party needs to take to fulfill the agreement. Once a draft of the final agreement has been compiled, then the mediator gives a copy of the agreement to each party to sign. The authors state that the parties are more likely to live up to the terms of an agreement if it exists in writing and has been signed by everyone. In conclusion, mediation is an excellent example of how conflict can be managed through communication. The role of a mediator is to serve as a neutral, unbiased third party who facilitates communication between conflicting parties so that they may reach a mutual agreement. Whether you serve as a mediator or you seek the help of a mediator, I hope this information has been helpful as you face conflict situations in the future.